Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about cocaine trafficking. Cases that should have gone to the Supreme Court of Canada, but didn't. Vito Buffone was charged in a conspiracy to import and traffic in cocaine in Canada. One of the issues that arose in his trial was the issue of proving that he was actually involved in the packaging and trafficking of cocaine. Some of the evidence that the prosecution led in the case included gloves. There was no visible cocaine residue on the gloves, but the gloves were tested and determined to have had contact with cocaine. Mr. Buffone argued at trial that the presence of cocaine residue that wasn't even visible to the naked eye on the gloves was not sufficient evidence that he was actually involved in handling of cocaine. That the absence of evidence visible to the naked eye raised questions about the validity of whether there was a proper analysis of the gloves done and whether there was in fact any real hard evidence of cocaine and cocaine trafficking. Mr. Buffone unfortunately was convicted and lost his appeal. He sought leave to appeal to the Supreme Court of Canada, who dismissed the appeal. And this case raises very important issues. As we know, drug residue can't always be seen. And of course, that is still nevertheless evidence in the sense that there is evidence that drugs have been present. But where the drug residue is not visible to the naked eye, to rely on the presence of that, which could come from just touching surfaces that have come into contact with something that has had cocaine on it, is a big stretch. And the Supreme Court of Canada ought to have weighed in on the value of drug testing and analysis evidence in the context of something that couldn't be seen to the naked eye. Everybody really has heard that saying that, if you test any random $20 bill, there'll be cocaine residue on it. So how does this not extend to things that are possibly touching other things like gloves, which are designed to be worn by your hands, which are the things that do the touching? It makes sense that this might be an issue that should be chimed in on by the Supreme Court of Canada because of the way that scientific testing is becoming so much more important in criminal trials and improving cases, and the way that science is advancing to the degree that it can test for the presence of something that is no longer there or visible to the naked eye, that scientific testing can go so far now as to essentially create evidence that otherwise never would have been obtained. And while we don't have good methods set out in the Criminal Code or the Controlled Drugs and Substances Act to challenge the scientific validity of these testings, nor do we have evidence available to defense lawyers about the nuances of the science, isn't it more important then to rely on common sense and our own visual observations to confirm what the science is telling us, as opposed to just saying, trust us, we're the government? This case raises important issues about that, and unfortunately the Supreme Court of Canada missed the opportunity to really delve into the issue of using science in the place of physical, observable, tangible evidence that can be taken to a jury and understood and appreciated in those circumstances. Hopefully the Supreme Court of Canada deals with another case involving scientific evidence about something that can't be seen or understood and really puts a limit or an outline on the description of how this information is going to be used by juries and by triers of fact in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.